petitioners are residents of a multi-storied building, different flat units they are occupying. Now, suddenly on 6th of December, corporation comes and pastes a notice that in terms of some direction passed in some matter in this honorable court, they will carry out a demolition work, we have to vacate. We said that we are not aware, no notice, nothing has been given, and we are the recorded assessees. Our name have been recorded for the past more than 20 years. So we said that kindly do not demolish because nothing has been forwarded to us. Then on 28th, they come back and demolish the ground floor. We obstructed that you cannot do this because no notice has been given. Without a proceeding, you cannot do it. On 20th, they went back with further notice that on 3rd, today, they will come back and demolish the rest of the building. Now, we made some inquiry and came to learn that one of the residents of the same flat, same complex, has lodged a writ petition. Her claim was that so far as hard deviation that may be regularized, the rest of the building be demolished, the rest of the deviations. This honorable court, the honorable single bench directed that they should initiate a proceeding for demolition. Nothing was served upon us. Appeal was preferred. The appellate court said restrict it to the ground floor. That is a division bench order, and she may also prefer regularization. This was the direction of the division bench. Now they come to demolish the entire building without any reference to us. So this action is bad, not in compliance of this court's order. This is my humble submission. They cannot do this without notice, without specification. How can they do this, my lord? Now the orders, my lord, are at pages 30 and 32. The honorable single bench order and division bench. Single bench was the entire building, but division bench was restricted to ground floor only. Page 30. And it was not assessed for the last 20 years. We have a right of audience, my lord. Kindly ask the municipality corporation whether they have served any notice or not. And one more thing, my lord. We have sent notice to the complainant. It is on dispatch. It is not served. Corporation have served. We have paid for dispensation because today they will come for demolition. Kindly give us some protection today. Otherwise, they will come and demolish the rest of the floors. Division bench order, lordship will find, my lord. Page 34, third paragraph is very clear. Page 34, third paragraph. We are ad idem with the learned single judge that the corporation must take necessary steps for removal of the unauthorized construction, if any, on the ground floor of the building in question. We hope that the corporation takes such steps expeditiously as no unauthorized construction should be ordinarily be allowed to stand. And then leave to pay for regularization. No reference to us. We are the other flat owners. Let them show me that we have been given a notice and heard. And on 20th, they came and demolished ground floor, the entire building. There are cracks in the entire building already. More than 25 years old building. Page 36 is the cracks, photograph of the cracks. Kindly give us some protection, my lord.
See, possibly it seems from the order dated 30th, order dated 21st of April, which is there at page 40, that the order of demolition was passed sometimes long back in January 23.
Let them show, my lord, that it was we are given hearing and
listen. Let them show is a different thing.
But
the order is there for more than 1 year. It is only the petitioner in that writ petition who challenged the same.
My lord.
Nobody challenged the same.
No,
so
because
accepted the order.
Nothing was served upon us. Unless the order is served upon us, how can we not challenge it? Nothing was served upon us. The petitioner, the complainant possibly made a complaint, and then
who is the complainant?
Complainant is one of the residents of the same building. Her flat also has some deviation as per her, and she asks for regularization. But we say, that our
from the order at page 30 it does not appear so.
She is the occupier, not the corporation can not, because they have served notice upon her possibly.
Yes, she has been served
She is
because
the
he was the
occupant.
complainant, my lord.
Yes.
Fact is this, he was the complainant, and unfortunately she was
The
trying
other flat
sit in the branch and to cut the. Actually, the promoter is the main person who has done it. 21 years their building was done, and she all on a sudden came to the and asked the corporation to demolish the ground floor. Ground floor, we have I can give your lordships the information as I have got the instruction. Ground floor we have already got demolished. 90%
What
already.
are the further portions that are
Other
required to
portion,
be
well,
demolished?
what happened, my lord, I should be fair to myself. So far as the ground floor also, what happened, ground floor has been made a change of user to some portions where shop rooms have been constructed, my lord.
The garages or the open spaces have been covered and enclosed
shop
to
room.
make shop rooms.
But in some portions, the garage is there. And in case of, and in that case, we have also demolished the garage also because they when go for demolition, they will do everything.
Milord, if there's a change
And-
of user,
আমাকে একটু বলতে দিন। And when my lord, the petition, some of the petitioners also owns a garage there also. I don't know, there is some dispute between that complainant and the flat owners. I don't know what happened. In fact, my lord, we have demolished most portions of the ground floor that was required to be demolished. Now what happens, my lord, when we go for demolition of the ground floor, thereafter, my lord, we cannot assure that the first, second, third floor, whether that stability will be touched or not. That we cannot assure. And my lord, I can be fair to myself so far as the persons whose deviations are there in the flats. They have not been pointed out that in their respective flats how much deviation was done. In their respective flats. If I say in the first floor, that portion. Second floor,
Regarding the
that
petitioner,
but they cannot go and demolish the entire floor itself because that belongs to different persons. So I am sure I can feel that their portion should be
no order is served upon us.
no, their portion should be accepted.
what is under challenge over here?
In this writ petition, Lord, the notices
Where
and
are the
notice,
notices?
Lord, page 29 is the first notice, 6th
29.
December,
And if they
and the
get
second notice there, page 42.
if they undertake that they will demolish their own portions, nothing happen, no problem. Their
No,
portions,
without a
their
proceeding.
portions we will ascertain after giving them a hearing, after giving inspection. That I am telling.
Let a hearing be given
Yes,
to us
that
whether
I-
we can, because
not only hearing,
assessed for 20
inspection will
years.
be done.
Yes.
Respective flats will be demarcated that you have deviated to that extent.
Page 29 and 42, my lord.
That we can ascertain. That I would submit fairly.
No, she's not part of us. The petitioner,
Your clients are occupying the said premises without a completion certificate being
Lord,
issued.
we are occupying, my lord, on the basis of the mutation given by the corporation for last
Mutated
20
is
years. We have
something else, only for the purpose of collection of tax.
collection
Now
of tax. my lord.
all the government officers have become paupers. So whenever you go and pay, they will accept money.
But
But that
assessment
does
will
not
not be
give
done.
any
That will not
right.
be mutated unless my lord, it is found in order. As per the provisions of the Act, my lord, they will find that the flat is in order, then only they will issue the mutation.
No, they will collect money.
And
Where
legally,
is
my
the
lord,
completion certificate? Prior to that, you could not have entered into the premises at all. Isn't it?
my lord,
It
in
means
that
that
case,
property is not complete.
in that case, they have to give us a notice that you produce your completion certificate. They have never asked for, they have not asked for anything. They have not
They
given
may
any
not
notice,
ask, but when you enter,
my lord.
you ought to enter into the premises only upon having all documents. You don't have those documents.
Your lordship knows how
Where is the plan? There must be a
Plan.
sanction plan.
plan we can produce. Plan
There
plan
is a
is there.
plan.
Yes, definitely. My lord. Plan on the basis of the plan,
G plus
the
5
the
is the plan.
promoter.
And G plus
Yes,
5 is there.
There is no float deviation. Now they are saying there is height deviation. That is what they are saying. For that we can pray for regularization also. The division bench kindly similar. Division bench said you can pray for regularization.
Residents are fooled also by the promoter. These promoters are doing these things.
No, that is for the
Lordship will kindly
occupiers to
see me,
sue
Lord.
the promoter.
The promoter itself.
But not for these steps to be taken, Lord, they have to first call us, they have to give us a hearing and
Please
show.
come.
আপনারা ভেঙে দিন আপনাদের আমরা স্পেসিফাই করে দিচ্ছি
22 writ petitioners have approached this court by filing writ petition challenging the
Lord, only one thing, my lord. The private respondent will have prayed for dispensation because of urgency I have not mentioned. Today they will come. So it's on dispatch.
challenging the notice dated 6th December 2023, allegedly pasted on the wall of the structure standing at holding number 44/1, Ramcharan Shet Road, ward number 44, PS Chatterjee Hat, under jurisdiction of the Howrah Municipal Corporation. Stop. Specific contention of the petitioners is that the aforesaid impugned notice was issued for vacating the subject structure and to make the structure available for demolition. Stop. Next. The petitioners submit that substantial portion of the building standing at the aforesaid premises have already been demolished by the corporation. Stop.
Most part is demolished, madam.
On 20th December.
Most of the parts are demolished.
And has been demolished by the corporation on 20th of December 2023.
And due
Stop.
to that, cracks are appearing in the entire building.
The
That we cannot assume.
the petitioners apprehend that the men and agents of the corporation shall take steps for further demolition of the premises today, that is 3rd January 2024. Stop. Paragraph. Specific case of the petitioners is that the order of demolition was passed without giving them any opportunity of hearing. Stop. The petitioners were never made aware of any order of demolition passed in respect of the subject property. Stop. Next. The petitioners are also not aware of the portions which are required to be demolished, allegedly, because the same were found to be constructed in deviation of the plan sanctioned. Stop. Paragraph. The petitioners submit that they are in occupation of their respective flats for nearly 20 years and their respective flats have been assessed separately by the Howrah Municipal Corporation, and the petitioners have paid taxes in respect of the flats in question. Stop. Paragraph. The petitioners contend that without details of the deviated portions being made known to the petitioners, they will not be in a position to demolish the same. Paragraph. Prayer has been made for passing interim order of stay of the impugned notice to vacate the subject premises and further restrain the corporation from taking any steps for demolition. Stop. Next. Learned advocate representing the Howrah Municipal Corporation submits upon instruction that substantial portion of the unauthorized construction has been demolished.
At the
Stop.
ground floor, madam.
In the ground floor.
At the ground floor has been demolished.
Stop. It has, however, been fairly admitted that the deviations at the individual floors have not been made known to the parties.
Not individual floors, but only the individual flats, madam. Respective flats.
Individual flats.
Respective flats. That is not been done. That I can clearly submit.
Individual respective flats. Stop. It has been submitted that the flat owners will be made known of the deviations in their respective portions so that the flat owners can demolish the same on their own.
Subject to order of this court. That may be included because
Subject to order passed by the court. Paragraph. Next. Copy of the writ petition is yet to be served upon the private respondents. Stop. Respondent number 4 is the developer of the subject property, and the respondent number 5 is the complainant, relying on whose complaint the order of demolition has been passed. Paragraph. Next. On a perusal of the impugned notice to vacate, it appears that the same is a general notice issued to all the residents / occupiers of the premises number 44/1, Ramcharan Shet Road. Stop. There are several flats at the said address. Stop. The deviations in respect of the individual flats may be different. Stop. Till the flat owners are specifically indicated about the deviations, they may not be in a position to identify the same for the sake of demolition. Stop. Next. In view of the above, the competent authority of the Howrah Municipal Corporation is directed to cause a spot inspection of the subject structure standing at 44/1, Ramcharan Shet Road, and to intimate the individual flat owners.
being the petitioners, my lord, only the petitioners, because
There may be others also.
others have not come to this court. So
But then if they will again come,
let them come, my lord.
again another litigation. What
It
the
is a
use?
deviation simpliciter. For that reason, I am saying that let them come. Thereafter, they pay before this court.
আচ্ছা, কি বললাম?
Only the petitioners.
Intimate the individual flat owners the deviation which are required to be removed. Stop. Next. The corporation,
Whether they will allow us or not, that is also a different, because they are not in the retreat.
the corporation shall specify the details of the deviations and communicate the same to all the flat owners. Stop. An opportunity of hearing shall be allowed to the flat owners, to all the flat owners. And thereafter, final order shall be passed. Stop. In the event any of the flat owners refuses to accept notice
My lord.
of inspection or hearing, then it will be open for the corporation to affix the notice of spot inspection and the notice of hearing
At the
at
conspicuous.
several conspicuous places in and around the subject structure. The subject structure. Stop. Affixation of notice of spot inspection and notice of hearing shall amount to good service of the notices. Stop. If final order shall be passed in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. Till a fresh order is passed by the corporation, the impugned notice dated 6th December 2023 and 27th December 2023
রিজেক্ট করবে।
It is only the notice dated 6th December, not 27th. ঠিক আছে, একটাই notice. Is directed to be kept in abeyance.
Not page 42 is also subsequently. shown
Page
to us,
page
but it
42
was
is not
to us.
addressed to
Not
anybody.
addressed to us. It has been supplied by the,
Yes,
shown to us. in
that is the
office.
reason only one notice is being directed to be kept in abeyance
Right.
until further order is passed by the corporation in this matter. The writ petition stands disposed.
No, only one humble submission I make, my lord. Page 34 of the writ petition, your lordship will see the division bench has given a liberty to the petitioner in that matter to pray for regularization if it so permits, if the rules so permits. Page 34, last paragraph. Because provision is there, my lord, we have a right to pray for it. If we pray for, my lord, they will consider. If it is minor, suppose not 10 square feet, 20 square
That is a different cause of action.
No,
As
same
of
same
now-
building.
As of now, only this. Thereafter, you see,
No, same building.
let them
If the,
let them say what are the portions deviated, not
after
deviated
pointing
thereafter.
out the deviation, we have a right, my lord, to pray for it. If it is a minor,
It will again come.
That is different thing.